Welcome to the Compliance Officer's Playbook podcast. We are jumping straight into what is, I think, arguably the most significant moment for digital asset regulation in the UK for a long time. Today, we're doing a deep dive into the newly passed Property Act. And, this isn't some minor footnote in a regulation. It's a really foundational legal shift that formally recognizes crypto as property.
It truly is. And our mission here, really, is to look past the headlines. You see all this talk about the UK becoming a crypto hub, but we need to focus on what this means for compliance, for operational risk. We're going to unpack the legal, the economic, and, the really crucial regulatory implications of the UK cementing this recognition. Because for companies operating in the market, sure, there's now clear property certainty, but that certainty comes with a whole new and pretty demanding set of requirements.
Okay, let's unpack this. It's a huge legal shift. So the headline fact is the UK has officially passed the Property, Digital Assets, Etc. Act. It's received royal assent, so this is binding law now. But I want to understand why this is such a seismic shift from how things were before.
Well, what's fascinating here is the sheer structural change in how these assets are categorized legally. I mean, to really get why this matters so much, you have to look back at the history of UK property law. For centuries, property fell pretty neatly into two established groups.
Right. The sources call them things in possession and things in action. Can you just quickly break those down for us?
Absolutely. So things in possession, those are the easy ones. Physical objects you can touch, a house, a car, actual cash in your wallet, tangible stuff.
Simple enough.
Then you have things in action. These are intangible rights that you can, only really enforce through legal action. Think of a bank balance or a debt that someone owes you.
Or shares in a company, that kind of thing.
Exactly. Intangible, but still rooted in these traditional financial structures. The problem for crypto has always been that it just didn't fit neatly into either box. It's not a physical thing, so it's not in possession. But it's usually not a debt owed by a specific person, so it's struggled to be called a thing in action. This new law basically creates a third category from scratch, specifically to include things like cryptocurrencies and NFTs.
Wow. So it gives them clear statutory property rights.
That's it.
That structural change alone sends such a powerful message, doesn't it? I saw Ite Katz, a big legal voice in this space, call it a welcome and timely statutory recognition. He said it delivers a decisive message to the world that the UK is open for business as a digital assets hub. It's a real statement of intent.
It's more than a statement, it's the groundwork. You have to have this. When you provide this level of legal certainty, you reduce risk. And that's what you need to attract global finance, to attract the big institutional investment, and all the innovation that comes with it.
Okay. That brings us perfectly to the practical reality. Let's move from the high-level legal theory to, what this actually means for an everyday holder or a company with digital assets on its balance sheet.
It means digital assets are now seen as having the same legal status as traditional property. And this certainty, it provides a few really crucial protections. It solves some real nightmare scenarios.
Like what? Inheritance must have been a total mess before this.
An absolute disaster. I mean, trying to clarify what happened to your crypto wealth when you passed away was so complex, so costly. Now, this act gives much better clarity for inheritance claims. It makes sure these assets are explicitly included in standard insolvency and estate processes.
So if a company goes bankrupt, the treatment of its digital assets is now written in law, not something to be debated in court for months.
Precisely.
And what about the worst-case scenario? Theft, fraud?
Well, stronger ownership rights mean you get improved mechanisms for recovery. If your car is stolen, the police, the courts, they know exactly how to treat that asset. When a crypto wallet was hacked, everyone was just navigating what the sources called piecemeal court decisions under common law.
Piecemeal just sounds exhausting and expensive.
It was. Imagine being a judge trying to recover stolen assets based on a handful of rulings from the last few years, trying to fit this super technical digital thing into legal categories from the 1700s.
A case-by-case scramble? No predictability?
None. Now, that status has statutory backing. The trade group Crypto UK said this gives everyday holders the confidence they expect with any other form of property. It lays the foundation.
So the message is, the UK has fixed the foundation. We have certainty, clarity, property rights.
That's the benefit, yes.
But here's where it gets, I think, really interesting and a bit complex. Usually when a government codifies something this important, they define every single term down to the last comma. But Parliament, They took a really intentional and kind of surprising approach here.
They absolutely did.
Yeah.
A crucial nuance in this act is that it deliberately avoids defining exactly which digital assets fall into this new category. They chose not to create some rigid checklist of, approved tokens or asset types.
Okay, but hang on. For a business operating right now, isn't that just a massive regulatory gray area? Doesn't that just invite years of expensive court cases until the common law finally catches up? Why give us a law for certainty, but leave the definition of the actual asset uncertain?
That's a great question, and it really gets to the core philosophy of how the UK's legal system works. Parliament's reasoning was pretty clear on this. They felt that setting out firm legislative rules today would make the law less able to respond to new technologies in the future.
So they didn't want to define themselves into a corner, basically, make the law obsolete in a few years.
Exactly. I mean, think about it. If they had written a rigid definition back in 2018, it probably would just included Bitcoin and Ethereum.
Right.
That law would be totally useless today. It would miss complex DeFi protocols, new stable coins, all these novel tokenized assets. By keeping the definition broad, they ensure it lasts. They're recognizing the category as property, but letting the common law system adapt the interpretation.
So they trust the judges to figure it out, case by case, as new tech comes along. That's a really key insight. They value that future adaptability over an immediate but maybe rigid definition.
It shows a real trust in the judicial system to evolve with the technology, which is kind of how traditional personal property law developed anyway, through decades of court rulings, not some big list from Parliament.
Okay, so that's the clarity side of the ledger. Legal certainty, property rights. Now let's flip the coin and talk about the compliance officer's new playbook. Because, as we always find on this show, legal clarity almost always comes hand in hand with heavier regulatory reporting.
It certainly does. If you're running a UK-registered trading platform, or even just operating in the UK, you need to be preparing for some significant new reporting mandates. These are set to take effect from January 1st, based on what was in the 2025 budget.
What are the specifics? What do platforms actually have to start collecting? This is critical for our listeners who are building these compliance systems.
Okay, so platforms now have to collect comprehensive data on their users. We're talking personal details, tax identification numbers, or TINs, and, crucially, comprehensive crypto transaction histories.
And that's not just a record of a deposit, right? This is deep historical data tracking.
It is a massive data collection and infrastructure exercise. It really changes the operational structure of a platform.
And what's the government's stated goal for this huge undertaking?
The goal is very clear: closing the tax gap. The government projects these measures will raise an extra $417 million in tax revenue by 2030. They are sending a very loud signal that the era of, let's say, anonymous, untaxed crypto trading in the UK is coming to an end.
From a compliance perspective, the burden of collecting and storing and securing all the sensitive data, TINs, transaction histories is enormous. What's the friction we're hearing about from the industry?
The friction is, it's coming from a few places. First, the operational cost. It's significant. Platforms have to invest heavily in new KYC systems, data storage, audit trails. But second, and this is the big warning, experts are saying this increased compliance burden could actually do the opposite of what the UK wants.
How so?
It could push some traders, especially retail or high-frequency traders, toward non-compliant offshore platforms that don't have these tough standards.
That's the classic regulatory challenge, isn't it? High compliance creates certainty, but it also creates friction that can push activity away. It costs more to play by the rules.
Precisely. So compliance officers now have to weigh the operational cost of this new gold standard against the risk of losing market share to entities that are less regulated.
And we can't really discuss UK crypto regulation without at least touching on the broader political context here.
That's right. The whole regulatory environment has also been shaped by this discussion around political donations. The government is looking at a proposed ban on crypto donations to political parties.
A proposal that has been widely seen as targeting parties like Reform UK, which started accepting crypto.
Well, it's just important to note this context as a sign of how engaged the sector is in the political sphere, which often fuels these regulatory responses. I mean, sources noted that the reform leader, Nigel Farage, had received significant payments for speaking at industry events. We're talking, $40,000 for a Blockworks Summit, $27,000 for Zibu Live, another $10,000 for Bitcoin 2025. So it just shows the sector is active. It's trying to influence the landscape, and that in turn accelerates the government's need for control and transparency, like these new tax rules.
Okay, so to summarize our deep dive today, The UK has solidified crypto's legal status. It's moved it from this common law gray area into a new third category of personal property. This gives huge clarity for ownership, for recovery rights, and for market confidence.
But this crucial legal certainty comes with some very heavy operational baggage. Compliance officers have to prepare for strict, new tax reporting requirements coming into effect next year. Requirements designed to raise hundreds of millions in tax revenue.
So here's a final provocative thought for you to mull over as you design your compliance infrastructure. If the UK's model statutory recognition, flexible definitions, but very strict tax reporting, if that becomes the global blueprint, does the massive benefit of legal certainty ultimately outweigh the high cost of regulatory compliance for the industry? Or will that friction actually stifle the very innovation the UK is trying so hard to attract? Thank you for joining us for this crucial deep dive into the UK's new digital asset legislation. If you loved this show, we invite you to become a paid subscriber today for $5 USD, and get full access to all premium episodes packed with insights, stories, and value you won't find anywhere else. The link is in the show episode notes.